Hello, everyone. On behalf of LiveLaw Academy, I welcome each one of you to today's session. I am Rohit Rohila, and today I'll be discussing one of the interesting topics from Hindu law, that is maintenance of widowed daughter-in-law as provided in Section 19 of the Hindu Adoptions and Maintenance Act 1956. This act applies not only to Hindus by religion. Rather, it is applicable to a wide range of people, including Jains, Buddhists, and Sikhs. And it is also to be kept in mind that this act has codified and amended the traditional Hindu law, and the provisions of this act, they have been given preferential treatment. By this, I mean that in case of any inconsistency with any previous rule of traditional Hindu law, any interpretation made, any custom or usage that had the force of law before this act came into force, and also including any previous enactment, be it central or state, all if those things are inconsistent with the provisions of this act of 1956, then the provisions of this act will prevail. Having said so, let's talk about the maintenance of widow daughter-in-law. So I have divided this session into two parts. Firstly, I'll be highlighting what is the position under traditional Hindu law, and then we can move on to discussing the provisions of the Act, particularly Section 19. And um, lastly, we'll try to find some cross connections within the Act and beyond the Act, what provisions can be related with Section 19. So speaking of traditional Hindu law, under the traditional Hindu law, there was only one person who is responsible for the maintenance of a of a widow of a deceased person, and that was the son. The son had the personal obligation to do so out of his personal property, out of his property, if he had any. And as regards any other person, the liability to maintain a widow was limited only to the extent that person had the estate of deceased husband in his hands. Now, the estate of the deceased husband could be in the hands of either the male issues or the coparceners. Let's discuss each one of them one by one with the help of example. So, the property of the deceased husband could be in the hands of a male issue. Suppose there is a family comprising of father, mother, and a son. Now, the father had died. The son had no private property, personal property of his own, no self-acquired property. But his father had left some self-acquired property, and definitely the son is going to inherit the same property, but he will do so because there is a mother, there is a widow, right? Widow of the father. So he will take this property subject to the obligation to maintain the widow out of the same property. Now let's take the example of coparcenary. Property of a deceased husband could also be in the hands of coparcenary, I have told you. Let's consider another example. Suppose there is a family where coparcenary is formed by two male members, father and son. The son was married. The son died in the lifetime of father. So upon his death, his coparcenary interest will elapse. Why? Because there was a rule of survivorship back then. So his coparcenary interest will elapse, and consequently, the interest of the father would enlarge. Here, in this situation, the widow of the son, her daughter-in-law, of the father, the surviving coparcenary, the daughter-in-law would have been entitled to claim maintenance from the father-in-law, but this maintenance would be subject to the it will be limited by the interest which the son would have got in case he survived, right? And here it must be noted that property can be in anybody's hands. The estate of the deceased husband can be in anybody's hands, and the person is under an obligation to maintain the widow, but this obligation is not a personal one, as we have discussed in the case of the son, in case he has his own personal property, right? This is not an obligation which is personal in nature. The obligation is put because the property, the estate of the husband is in the hands of somebody. So that is the rationale behind it. Now, this was the position under traditional Hindu law. When Hindu Adoptions and Maintenance Act it came into force, it brought sea changes in terms of adoptions as well as maintenance, and Section 19 is another example of the same. Let's see what is prescribed under Section 19. Let me just share my screen and we'll read it together and understand the text first. Here, Section 19, maintenance of widowed daughter-in-law. It is provided that a Hindu wife, whether married before or after the commencement of this act, shall be entitled to be maintained after the death of her husband by her father-in-law, provided the first part puts an obligation on the father-in-law, but the second part makes it conditional. Let's see. Provided and to the extent that she is unable to maintain herself out of her own earnings or property, or where she has no property of her own, is unable to obtain maintenance from the estate of her husband or her father or mother, or from her son or daughter, in if any, or his or her estate. Right? The first thing that we need to note under Section 19 is this phrase, whether married before or after the commencement of this act. This phrase actually makes Section 19 both prospective and retrospective in nature. Right? It has a retrospective application as well. It does not matter when the marriage actually took place. It covers those situations where the marriage between the son and and her took place even before the commencement of this act, right? Now, the next thing we need to understand, we need to ask ourselves this question to understand Section 19 in a much better way is, what is the nature of liability of father-in-law? What kind of right is provided to the daughter-in-law against the father-in-law when it comes to maintenance? The widowed daughter-in-law, right? When it comes to maintenance. See, we can say that the right granted under Section 19 to the daughter-in-law is conditional in nature. Why? Because it is contingent upon the fact that she must be unable to maintain herself, right? And this maintenance could be either out of her own earnings or through a property. If she is able to maintain herself, then the liability of father-in-law does not arise. Hence, the liability is conditional. Then, not only this, she must not be able to maintain herself out of her own earnings or property. She must make a claim to the estate of the husband or to her own father or mother, and after these categories, from her son or daughter or from their estate, right? So she has to exhaust these things first, then only claim can be made against the father-in-law. Now, this was not there under the traditional Hindu law, we have seen, right? And it is further conditioned by subsection 2, right? Condition is put by subsection 2. Let's see. Any obligation under subsection 1 shall not be enforceable if the father-in-law has not the means to do so from any coparcenary property in his possession, which means now it is something similar to traditional Hindu law, which means the liability of the father-in-law is restricted only to the extent he can do so by or through a coparcenary property in his possession, which means his own property cannot be touched for the purposes of Section 19. Hence, we can say that though first part puts an obligation on the father-in-law to maintain widowed daughter-in-law, but the proviso in subsection 2, they put a limitation on this right of daughter-in-law and make it subject to certain conditions. First, she has to seek different avenues before making a claim against father-in-law. Second, even if such a claim can be made, the liability of father-in-law will only be restricted through to coparcenary property and not his own self-acquired property. Right? Now, the next question that we need to consider is whether there is any preferential precedent here, which means whether the widow daughter-in-law has to follow the same sequence of making a claim to different persons as provided under proviso, right? She has to make a claim against the estate of the husband first, then against her own father or her mother, right? Or the sequence need not be followed. The commentators on Hindu law, they are of the view that though the words or is used everywhere in the proviso, but the proviso can be divided into two parts. And these categories given in clause A and clause B of the proviso, right, they actually sequential in nature. So a daughter-in-law, in order to make a claim against father-in-law, has to go to the if she is unable to maintain herself out of her own earnings or property, then she has to first make a claim against the estate of the husband, then her own father, then her own mother, so on and so forth, then son, daughter, their property, and lastly, the father-in-law. You can find a discussion on the same on page 1445 of 25th edition of Hindu law by Sir D.F. Mulla. Though no authority has been cited to back this, but this seems to be the logical view. Why? Because of these words also is unable to obtain maintenance. So there is an embargo here that in order to make a claim against father-in-law, first she has to make a claim against these people, and only when she is unable to obtain maintenance from them, then only father-in-law's liability arises. Right? These words are of great importance here. Is unable to obtain maintenance from so and so. Right? Next, we can consider, since this is in relation to subsection 2, since the liability of the father-in-law is only limited to the coparcenary property. So for the purpose of section 19, let's briefly understand what is coparcenary property, though discussion on coparcenary property can take days because there are many details to it. But for the purpose of section 19, a brief discussion can also happen for today's session, right? For this, you can note down one authority from Delhi High Court, Daljit Singh versus S. Dara Singh. This was AIR 2002 2000 Delhi 292. Now, in this case, after referring to several authorities, the Delhi High Court first discuss the concept of coparcenary property, because in this case, the daughter-in-law made a claim against various members of the family of the husband, including the father-in-law. Right. So in order to decide the matter, reference was made to Section 19, and naturally, coparcenary property was needed to be discussed. So after referring to several authorities, the court very in a simple language has provided that the property for the purpose of Hindu law can be divided into two categories broadly. One is joint family property, and that is coparcenary property, and another one is self-acquired property. Then the court goes on to say that the joint family property can be further classified on the basis of the source from which it actually comes, right? So it can be ancestral property, or it can be a self-acquired property which was thrown into the common stock of joint family, common stock of coparcenary, right? So ancestral property is a species of joint family property. So normally you will find people using these terms as if they are synonymous, but when we understand the true nature of these, the logical conclusion is ancestral property is a species of joint family property, right? Then in this case, after discussing the definition and other cases, the court closed its discussion on what is meant by coparcenary property, then went on to discuss the facts. So in this case, as I said, that claim was made against the father-in-law, including other family members also. So the widow daughter-in-law, made a claim under Section 19 against the father-in-law, but she was unable to pinpoint as to what coparcenary property is in possession of father-in-law. So the court said nothing was shown by her as to which coparcenary property should be taken into consideration. All the properties referred to by her were self-acquired properties of the father-in-law. So the court decided against her. And from this decision, one more thing is clear, that the burden of proof lies on the widow daughter-in-law to show that there is a coparcenary property in the possession of father-in-law. Unless that burden is satisfied, relief cannot be granted to her, right? And if you want to read further on coparcenary property, there is an interesting discussion by Punjab and Haryana High Court in the case of Gurdeep Kaur versus Ghamand Singh Deva. Gurdeep Kaur versus Ghamand Singh Deva, AIR 1965, Punjab and Haryana 238. And if you want to understand how a self-acquired property becomes joint family property, what are the conditions, then you can read a judgment of the Supreme Court given in KV Narayanan versus KV Ranganandan, KV Narayanan versus KV Ranganandan, AIR 1976, Supreme Court, 1715. 1715. Now, let's consider the self-acquired property of father-in-law. Can a claim be made against the self-acquired property of father-in-law under Section 19? The answer is no. The language is plain and simple, and the legislative intent must be upheld. And as such, in light of subsection 2, if the father-in-law only has self-acquired property and no coparcenary property in his possession, then a claim under Section 19 cannot be made against him, right? But is there a situation where daughter-in-law will be entitled to such self-acquired property? Can she be entitled to a share in the said property? Is there any situation? So self-acquired property can be disposed of either through testamentary succession, right? Or through transactions like sale, gift, etc. And if there was no will and no such transaction, then upon the death of the person, that is person dying intestate, then the rules of Hindu Succession Act in case of Hindu, they apply, and intestate succession rules can be followed and individual shares can be decided. So if father-in-law had self-acquired property, he did not make any will, the property was not sold to anybody, gift was not made, etc. Nothing of that sort was done. And now there has to be an intestate succession of the said property. Then I would like to invite your attention to Schedule of Hindu Succession Act. This schedule provides us the list of class 1 and class 2 heirs of Hindu. And when you see class 1 heirs, here widow of a predeceased son is mentioned. So she is a part of class 1 heir. And class 1 heir, as you know, that they take simultaneously and to the exclusion of class 2 heirs. Right? So she has a preferential right over class 2 heirs and simultaneous rights with other members of class 1 heirs. Right? So this can be one situation where a claim can be made against the self-acquired property of a father-in-law, though not under Section 19 and not during his lifetime, but only if he dies and he dies intestate, right? Then there are some cross connections that I told you that I'll be referring to them, some other provisions of the Act in order to make the understanding comprehensive. So the first cross connection is with respect to the application of Section 19, the application of Section 19 to scheduled tribes. For this, we may refer to section number 2 of the Act. Let's see. Section number 2 of the Act. See, Section 2, subsection 2. Notwithstanding anything contained so and so in this Act shall apply to the members of scheduled tribe within the meaning of Clause 25 of Article 366 of the Constitution, unless the central government, by notification in the official gazette, otherwise directs. So there has to be a specific direction by the central government in order to apply the provisions of this Act to scheduled tribes, and including Section 19. So there is no direct application to scheduled tribes. Though application of Hindu law in case of tribes, it requires a lot of effort to understand. There are many decisions that one can refer to, but we'll cover it some other day. And a situation where in lieu of maintenance, some property is given to the daughter-in-law. So if in lieu of maintenance some property is given, maintenance is a pre-existing right. So if in lieu of the same right some property is given to her, then definitely it will form part of Section 14 of the Hindu Succession Act. And Section 14 Hindu Succession Act actually transforms the limited estate to absolute estate, right? And for this you can refer to a judgment of the Supreme Court, Balwant Kaur versus Chanan Singh. Balwant Kaur versus Chanan Singh, AIR 2000, Supreme Court 1908. AIR 2000 2000, Supreme Court 1908. Right? And lastly, we need to understand that provisions of Section 19 are to be read subject to provisions of Section 23. Section 23. Section 23, subsection 1, please make a note of it. It shall be in the discretion of the court to determine whether any, and if so what, maintenance shall be awarded under the provisions of this Act. Right? Now this includes Section 19 also. So it is in the discretion of the court to decide whether maintenance is to be paid, and if yes, it is to be paid, then what should be the quantum of it. And then Section 23 goes on to provide a list of various factors that are to be considered, right? But the relation between 19 and 23 is that it is in the discretion of the court. But discretion has to be exercised judicially. There should not be arbitrary exercise of discretion, or we should not exercise it capriciously, right? Capriciously means without any meaning, with absurdity. So arbitrariness will lead to absurdity, definitely. So that's all as far as maintenance of daughter-in-law under Section 19 of Hindu Maintenance, Adoptions and Maintenance Act is concerned. And I hope that you found this video informative and of some relevance to you. And if that is the case, please do not forget to subscribe, share, like, and comment. And we'll meet again in more such informative sessions. Thank you.